that should be before other tribunals. And the Supreme Court has told us that in Bellevue, that the conduct of a judge, because that's what is being alleged here, a judge is being alleged to have concealed information that they ought to have given. A judge is being alleged to have abused office by sitting on a particular day and whatnot. So those are things that really should not be a subject of a proceeding if we really intend to proceed with this matter. Suppose this bench does not recuse itself, then how does the matter proceed in that manner? I'd like to point out that I think I've already talked about the fact that the facts relating to a recusal, the person who really knows what those facts are and the extent to which they are is the judge. And so any discussion as to whether we've proved a case or not proved a case is neither here nor there as relates to this issue. I'd like to refer the court. I don't know how we quote precedents, but I'd like to refer the court to a decision of the Supreme Court of the United States in Jewel Ridge Coal Corporation versus local number 6167, United Mine Workers of America in 1945. And there the court, the Supreme Court, found that I think one of the parties was asking for the entire bench to recuse themselves. And I'll just take maybe one more minute for the entire bench to recuse themselves. And the Supreme Court of the United States found that that decision cannot be made by the bench. A question of recusal should be directed at the judge, and it should be the judge to make the decision whether we themselves will recuse themselves or not. It was also, again, captured in 1980 in a decision called Hanrahan versus Hampton, still at the United States Supreme Court. And in India, in 2016, Advocates on Record Association and others versus Union of India, Justice Madan also pointed out the same. And finally, I'd like to refer the court to the fact that this is a sensitive matter, but is also, as sensitive as it is also an urgent matter, as considered by the bench and as considered by everyone. That there is the aspect of necessity that this matter must be heard. And there's also room for appeal should any person feel they are aggrieved by decisions of this court or the judges herein. And so what I would say is that I would ask that the individual justices, that you look into the issues that have been raised, you look into the facts which you are familiar with them yourselves, and go home and reflect whether indeed you will have the impartiality to hear this matter. And once you make that decision, let's hear the matter and proceed. Thank you.
My lords and my lady doctor, if it pleases you in the matter, my name is Wamboi, Shadrach Wamboi. I speak with the blessings of my senior, Mr. Danstan Omari and Samson Nyaberi, on behalf of the 9th petitioner. My lord, at the very outset, permit me to submit that this court has a duty, either individually or as a collegial bench, to hear and determine the matters that are presented before court. Indeed, just like any other person, you have a duty to act in the defense of the Constitution. However, matters that relate to the calling to question of the conduct or the integrity of the bench or a judge are matters that are characterized in this country with a lot of rage, as we have even seen being demonstrated in this honorable court. In other occasions, applications for recusal, my lady and my lords, are said to be a dialogue of the deaf and a dance of the blind, to the extent that the petitioners or the applicants making an application such as the one that finds itself before you sometimes refrain from even saying the very grounds upon which they make the application, as you have seen before this court. And again, the bench on the other end, on many occasions, tends to draw conclusions of what they would think the applicant is saying about their conduct or their integrity. So for that reason, my lady and my lords, the court is then called upon to reflect as to its duty to do that which is just vis-a-vis the perception, either actual or apparent, that will flow or be submitted by applicants who call to question the conduct of the court. My lady and my lords, permit me to also make a contribution with regards to the decision that has been made in the Supreme Court case of Dari Limited. And there is something that is important that we must highlight. In this application, the Supreme Court was not called upon to adjudicate on an application for the recusal of the court. That was not the application that was lying before court. What is important that we must underscore in this case is that the court was invited to suspend or stay its proceedings in view of a complaint that had been made by the applicants before the Judicial Service Commission, so that the court ultimately ended up recusing itself, not that it had been invited to recuse itself, but because there had been a complaint that had been filed before the Judicial Service Commission. My lady and my lords, the reason why the 9th petitioner rises in support of the submissions made by counsels who have made the application is largely due to our duty as the officers of the court. And we have seen in the application in petition number E015 of 2024, annexure marked DMM2, which is a letter addressed to my colleague Mr. Swanya of Swanya and Company Advocates from the Judicial Service Commission, highlighting a complaint that has been made by the Deputy President of the Republic of Kenya, His Excellency Rigathi Gachagua, against this honorable bench. So, my lady and my lords, as I rest, the question that begs the answer is simple. If a complaint has already been lodged against the persons of this honorable court, how will a reasonable person, or will a reasonable person out there be confident that this court, in light of the complaint that has been lodged against you by one of the petitioners, arrive at a just finding in this case? My lady and my lords, that should mark the end of my submissions. I shall pave the floor for the remaining minutes to my seniors to also speak some wisdom to what is in issue. Thank you.
My lady and my lords, my name is Sam Nyaberi, for the 9th petitioner in the second cohort. I stand in support of the motion for recusal, and I juxtapose it in this manner. Recusal applications are tantamount to the court being on trial. It's a charge sheet for the court that it then will determine the parameters that have been set and the grounds that have been adduced to find or make a finding whether they merit. And in so doing, the court will not be given an opportunity to make submissions as we are doing. It's the court that is going to now render a ruling. Then the big question that we ought to ask ourselves, whether then the court is going to rebut on the heavy submissions that have been made, because going into the second room of going to analyze what the petition is all about will mean that we as the petitioners will have faith in even opening the second chapter of the proceedings as they are going to happen. So therefore, my lords and my lady, the point we are making is, kindly, there is enough evidence that has been laid before you to make a determination that indeed it is not available for the court to open the second chapter of going into the determination of the petition. I rest my case there. The balance of my time, I invite Omari to finish up and conclude.
My lords and my lady, mine will be very, very brief. One, the court, in determining whether the DCJ has powers to constitute a bench, made a finding that the petitioner was found guilty of an offense of addressing the gallery. His lawyers, all of them, never addressed the court. The lawyers were not addressing you. It is the petitioner who was addressing you. You have already made a decision that the petitioner was addressing the gallery. Will he have confidence to appear before you? Ahmed Nasir Sr., when he was constantly spotted by the Supreme Court that he was attacking the courts, the court decided to punish. When he appeared, all the members of the Supreme Court recused themselves. They never gave him audience. Will the deputy president have audience before you when the main substantive motion comes before you? You have already made up that his job is to address the public. The rationale for this matter, going live and my brothers and sisters saying it's a public interest matter, is because 55 million Kenyans are waiting to see the free learned judges appear impartial. It is our submission from our client Sharia Mtani that based on that, you recuse yourself. I'll give a small analogy. When I went to pay dowry for a friend of mine, we were told that that place, those people were witches. So that religion, when food is being prayed for, you must close your eyes. We never closed our eyes because behind us we feared, my lord and my lady, that these guys might destroy us. The petitioner is scared of this page. That's my lord.
I withdrew with all parties supporting the application. In that case, Professor, you can continue.
Thank you, my board and members of the bench. I will try to be brief. My colleagues and I, I think, would like to be truthful. First, we would like to begin by observing that today is the 10th day since this bench was constituted. It was constituted on the 14th of October. There were petition 522, petition 550, petition 569. Nobody ever complained at all until we came here on Monday. And even then, the complaint was an ambush. The petitioners appeared before my Lord Judge Ogola on the 16th of October. Orders were made in their favor. They were extremely happy. No complaint. The three judges of this bench were in the bench in 522 of 2024. No complaint. This complaint is a complaint founded on the fact that on the 18th, the Honorable the Attorney General, for the first time, also got orders Now, that is when this bench became a bad bench. It was a very good bench for as long as it gave any order to the petitioners. It became a suspicious bench when it gave an order, only an order to expedite the hearing. The Attorney General had wanted many things. They were all declined. I will address you, my lords, on the understanding that we have two petitions. There's one petition I call the Kerugoya petition. And there is another petition I will call the Nairobi petition. It is our preliminary submission that yesterday's ruling of the 23rd substantially addresses the issues raised in the Kerugoya petition, and that those issues are now, they are res judicata. There is issue estoppel. There is issue estoppel, a doctrine of law that states a question that has been resolved by the court cannot be litigated afresh in the same proceedings. It is our second submission that the first limb of the Nairobi petition on recusal that speaks to how the case was handled between the 18th and the 22nd is also substantially settled by yesterday's ruling. And I think my learned friends, most of them, were able to confirm that. And they complained about that. No. So what issue is alive? The only issue that is alive is the issue of recusal, allegedly on the grounds that I'm so happy that my lady has been spared any further unwarranted attack as regarding her standing. So I will not make any reference to that. It has been considered that it was made recklessly without any factual basis. And I think that what an ethical advocate of the Honorable Court should do is to start by saying, I apologize to her leadership for these allegations that are contained in a document that bears my signature. But that is not for me to say. So let us proceed to the two other allegations. At one point, I was very surprised to hear a submission that said that my Lord Justice Ogolla is close to his wife. How can that be? How can that possibly be a bad thing? But a further extension of that argument was equally spurious. A professional person is entitled to an independent professional existence. Be it the husband, be it the wife, be it siblings, be it children, they have independent professional. And I am shocked that that can be a ground. Another ground now made is that the Honorable Justice Murima is a friend of the Speaker of the House. The Speaker of the House was my student. I don't know whether I should recuse myself. My Lord, if I may say this with respect, I have been a law teacher for 38 years. I apologize that that's not very long. There, 3/4 of the lawyers under the age of 50, I have taught them. I don't know whether I should recuse myself each time I appear against, including the Honorable Tom Ojienda here, Senator. Could you confirm that?
I confirm that you're my teacher.
Yes. And Judge Morogaru, Senator, the Solicitor General, the Attorney General, this is the nature of our profession. This is the nature of our profession. The Speaker is a member of the legal profession. The Honorable Justice Murima is a member of the legal profession. How else are we to do our work? Paul Kibugi Moite, Senior Counsel, a personal friend for many years. On the day I got married, he brought me a copper coffee dispenser. Am I never to do any case with him? Should I always tell people, I know Paul Moite from when I was mayor, he came to my wedding, he brought me a gift. It cannot possibly be. That is not how this profession works. Let me very quickly set this, what we believe, is the standard. The standard is set in the case of the most important of this all is the Rai case, which has been talked about. When will you ask for an accusal? And I agree with Dr. Kamino when he says that no lawyer, no advocate should ever make an application for accusal lightly. Indeed, an advocate approached by a client who is making personal attacks against a judge that are baseless must return the brief to the client. That is the honorable thing to do. Now, I have referred you to the Rai case, but the most important of this all is the objective test that is set in the Rawal case. In the Rawal case, which you are aware of, Rawal versus Judicial Service Commission, the court says there is no basis for a judge to automatically recuse themselves when a bare allegation is made by a party. The allegation must be substantiated. First, they now quote the Court of Appeal. Firstly, it is obvious from the above test that there is no basis for the rather elastic test propounded by Dr. Kaminwa, where a judge must automatically recuse himself or herself upon the making of a bare allegation of any of the parties. We have not come across any authority in support of the proposition, and Dr. John Kaminwa did not provide any. On the contrary, decisions abound that judges must not recuse themselves on flimsy and baseless allegations. It is our submission that a claim that the friendship that may exist between a party and a judge because they went to the same school, because they went to the same university, because they come from the same county, that is baseless. It must be demonstrated, like was said in the case of Kaplan and Stratton versus Z Engineering Construction Limited. If disqualifications issues were to be raised, say, because a judge and a member of the bar belong to the same Rotary Club or the same Lions Club or the same sports club, there would be no end to such approaches. There would be no end. In this case, it has not been demonstrated that there is any way in which the independence of any of the judges here can be said to have been compromised. Let me say something relating to the Dari case, because I was involved in that case, again with my very good friend, the Honorable P.K. Moite, on one side, and my friend Paul Nyamodi. They were on one side, I was on the other side. I think that's why Mr. Nyamodi has now come back to my side, because we were the successful party in that case. And as one of my learned juniors here on the opposite side has stated, you need to understand the context of the Derrick case. Because at paragraph 24, the court states this: the appellant's applicants herein are seeking a stay order from this court in the most unusual, strange, and dare we say disingenuous strategy. What had they done, my learned friends? We had litigated for a very long time. Litigated in England in the High Court, litigated in England in the Court of Appeal, litigated in the High Court here, litigated in the Court of Appeal here, litigated in the Supreme Court. And their final card, they had made a complaint against the Supreme Court. And what they were asking the Supreme Court to do is stay proceedings as we go to prosecute the allegations we've made against you. And I think the Supreme Court threw the sink at them. And that is why the decision says what it says. Now, I want to wind up by saying that if this court were to accede to this application, it would throw into disarray a critical public interest litigation when the country is in the throes of a serious constitutional crisis. And that is why philosophers like Dr. Muthomi say that cities burn, as philosophers are quibbling on whether we need a bucket or a pipe to put out the fire. We are in the throes of a grave constitutional crisis. The court that we have been given to resolve this issue cannot stop sitting on the basis of the most flimsy allegations of friendship between parties, because I don't know of a single representation here that is not related to another. If you opened this door, you will have created a precedent where all a lawyer needs to do, an advocate, all he needs to do is to make a connection. To make a connection. You go to the same church. You go to the same mosque. You used to work in the same chambers. You were trained by the same pupil master. Our connections will never see. Like they say about tort actions. There can never be an end to tort actions, and there can never be an end to the relationships we have in the legal profession. An applicant must demonstrate that because of that relationship, there is reason to believe, demonstrated by either past behavior, past judgment, past ruling, past conduct, that a judge will be biased in any way. But ultimately, as the authorities I have cited to you state, a judge has taken a judicial oath. A judge has a judicial oath. He answers to his conscience and to his oath. And finally, I will say, because I've had the great privilege to sit as an arbitrator in numerous matters, both locally and overseas, I have never found a standard that requires that that a person who has a historical connection with somebody, without demonstrating more than that, can be the basis of recusal. I will now hand over, before Madam Timekeeper asks me to my learned friend, Mr. Gould.
My lords and my ladies, for completeness of our record, we have filed grounds of opposition. We also have filed a list and bundle of authorities, all dated the 22nd of October 2024. My lords and my lady, permit me to start by saying that judges, just like they sit to determine disputes between parties who come before them. That is what makes us a country governed by the rule of law. In that duty, my lords and my lady, it is important that we ensure there is efficiency in the conduct of that very important responsibility. That is on the one hand. On the other hand, it is important that judges then guard against manipulation of processes. In the context of what we have, proceedings like we have today, the manipulation of process could manifest itself in the form of forum shopping, where we say that I will file this matter before this court, and before this court. In my hope, one of them will give. And that if I run into headwinds in any particular direction, then I must, as of necessity, run away from that court. My lords and my lady, this is a position that has been adjudicated, the fact that the court has a duty to sit all the way to our Supreme Court. We have in our list and bundle of authorities provided, cited one of the cases as being a case of Gladys Beausoleil versus Judicial Service Commission and a second party. At paragraph 5 of that decision, the court says that the doctrine of duty of a judge to sit, though not profound in Kenya's jurisdiction, then there's a spelling mistake. Every judge has a duty to sit in a matter which they should duly sit in. Recusal should not be used to cripple a judge from sitting or to hear a matter. That duty to sit was buttressed by the fact that every judge took an oath of office to serve impartially and protect, administer, and defend the Constitution. In yet another decision, Peter Mwangi Gishuru versus the Attorney General and the Salaries and Remuneration Commission, at paragraph 61 of that decision, the court says, the court has a duty to sit on matters presented before it for resolution and should only recuse itself where circumstances permit, but not where it will create an unconstitutional moment by refusing to hear a litigant's case because the opposite party apprehends bias. In what context, then, should we understand that jurisprudence? My lords and my lady, it must not be lost on us that when we are dealing with momentous topical issues of conversation in a country such as Kenya, like what we are dealing with, these matters evoke emotions. Just like in our election context, whenever a party loses, it is never so easy to accept the result of that loss. It is for that reason that sometimes people have all manner of aspersions cast against the court, against the independent, let's call it all other independent organs of the Constitution, because a decision has gone one way or the other, in instances not favorable to one party and favorable to another. We must appreciate that we are in an adversarial system where, as of necessity, a decision will be determined or will be made in favor of one party as against the other. That said, my lords and my lady, learned senior counsel Professor Githu Muigai has made reference to the fact that the matter that is before you, though dubbed as recusal, is a matter whose subject matter has been completely determined. There is issue estoppel, and that everything that has been presented before you today are issues that were contained in the ruling that your lordships issued yesterday. As a starting point, I would make reference, my lords and my lady, to the application that was filed yesterday by our opponents. The application seeking to have questioning the empanelment of this bench. If you look at paragraph Y of that application, on the grounds on the face of the application, my lords and my lady, the court was invited particularly to recuse itself. It then means that that motion for recusal was a motion that was live before this court. That motion was live between the same parties. It touched on the same issues that were presented before this court. The court pronounced itself on all those issues. What then is the business of bringing those issues through this second court application in the name of an application for recusal? My lords and my lady, if at all, as we now see, the applicants were not satisfied with that decision, the ruling of this court, the option that was available for them was to appeal that decision. Presenting this second application does not in any way open for them a door other than for purposes of delaying these proceedings. And I would say that with tremendous respect to my learned friends from the other side, and so that I am able to demonstrate, permit me to just look at the applications that have been filed and the issues that have been raised in those applications. I'll start with the application filed by my good friend, Dr. Evans Ogada. In his application dated the 21st of October 2024, he raises as ground number one the issues of the certification of these matters on the 18th of October. That was an issue that was before you yesterday. At paragraph 3, so that we understand context, he also says that on the next day, being Saturday, 19th October 2024, the petitioners were surprised by the turn of events wherein they were served with an order of this honorable bench stating that the first and sixth respondents' applications dated 18th October 2024 was coming up for inter partes hearing. Again, that was an issue that was before you. At paragraph 4, it talks about the subsequent reference of the matter by the Chief Justice to the Chief Justice on the 18th of October. That was an issue that was before you. Finally, he questions the unclear circumstances that led to the placement of the file of this bench on a Saturday before you without the express directions of the Chief Justice. Again, my lords and my ladies, that was a matter that was before you. In the application by Mr. Njiru Ndegwa, again, the same thing. First ground, that the petitioners have learned that this bench sat on a Saturday, the 19th of October 2024. That was an issue that was before you. Paragraph 2, it says that the petitioners were surprised by the sudden turn of events, again the same language used by the other application, in the other application, a matter that was before you. Paragraph 6, it says that the petitioners are apprehensive that this honorable court has clearly demonstrated that the case for the Attorney General is more important than our petition, yet they are raising similar issues. Again, that issue was before you, and it was determined. Paragraph 8. Let me stop first there. How then do we treat all those issues that were before you? And if we're, just so that then we understand that these matters were before you, when you delivered your ruling, which was shared with us this afternoon, from paragraph 73 all the way to paragraph 96, each and every of these issues were responded to. I mean, determinations were made. At paragraph 79, for instance, the court says, but backed by this sequence of events, we take great exception to the petitioner's conduct that when favorable to the petitioners, orders issued outside the normal working hours of a court raise no concern. However, when the same court acts in an instance where it has been properly moved by the other parties and likewise proceeds to deal with an application at hand in the same vein, the petitioners show their indignation. That was a finding that was made. At paragraph 96, you even go further to say that one of the senior counsels went further by intimating that an exercise akin to the radical surgery may be forthcoming, a statement which we perceive as a veiled attempt at intimidation coming from senior counsel. My lords and my ladies, what is left that you're supposed to determine again? It is an attempt to have a second bite at that which has already sailed. If for one moment we were to look at this application by Mr. Ndegwanjiru, he then introduces very strange allegations which he has had to withdraw. Everybody saw his discomfort at making reference to those issues. But as we all observed, these issues around making allegations and running away from them are meant to cast aspersions and indirectly intimidate the court. Permit me to say, or to make reference to paragraph 8, where they say, for instance, that the petitioners have credible information that Honorable Justice Mrima is a close associate to the proposed Deputy President, one Mr. Kithure Kindiki, and that the said judge failed, refused, and or neglected to discuss